you everybody for tuning into the podcast today. I am Mike Monteforte and I have my good friend Barbra Black with me today. We are actually in the same building. We are both attorneys. We've known each other for a little while. I'm very excited about this one because she's got lots of great information to share. So Barbra, thank you so much for doing the podcast with me today.
My pleasure.
I appreciate it so much. So first and foremost, if you wouldn't mind giving a little information just about who you are and your practice and kind of what you specialize in, that'd be awesome.
Sure, I'd be happy to. So my firm is known as the Black Law Group. We practice actively in both Massachusetts and New Hampshire. We have 6 attorneys in the firm, 4 partners and 2 associates, and some paralegals and legal assistants as well. I split my time between both Massachusetts and New Hampshire. I'm licensed in both states. The vast majority of our attorneys are dual barred in Massachusetts and New Hampshire. I have 1 lawyer who only does New Hampshire and 1 lawyer who only does Mass, and everybody else is dual barred. Primarily, our firm focuses on divorce and family law. And divorce and family law can be quite a spectrum of cases.
Yeah, you bet.
Divorce, everybody understands what a divorce is. The laws are different depending on what state you're practicing in. Divorce and family law is very state specific.
Yeah.
We also do a lot of cases that arise out of a divorce. For example, when a divorce is over, there's been a change in circumstance, somebody loses their job, for example, would be a perfect example of a change of circumstance. We would then be able to represent someone with respect to a modification action.
Okay.
Custody often is something that comes up post-divorce where something has changed in the circumstances of the parties. Somebody's moving further away, somebody's job has changed, maybe a parent is ill, or there may be circumstances where the child may have some special needs that have developed and the parenting plan may need to be revisited.
Right.
So that would also be a modification action.
Gotcha.
The other type of post-divorce action that we often handle are what are known as contempt actions.
Yeah.
So when you are divorced in either state, you're going to end up with final orders. We call them orders in New Hampshire and Massachusetts. We call them judgments. And those judgments are enforceable in the future. If someone doesn't comply with those judgments, then we would potentially bring a contempt action. So an example would be there's an order to pay child support or alimony, and the former spouse either doesn't pay the correct amount, doesn't pay on time. I have one of those going right now, or doesn't pay at all.
Yeah.
So these are cases in which we're trying to enforce a judgment or an order that has already been approved by the court and the person is not in compliance.
Gotcha.
So those are the 3 sort of big categories of family law cases we do. We also represent parties that are getting married, who may want to have a prenuptial agreement, which is a contract between the parties. These are valid contracts in both Massachusetts and New Hampshire. Pretty considerably enforceable in my experience in both states. And sometimes, though less common, we do postnuptial agreements.
Okay.
These are parties that are already married, that either have a change of circumstance, that they feel needs to be addressed by some sort of contractual agreement, or more often parties are potentially having marital issues and want to specifically put down in a contractual format what would happen if the marriage is unable to be saved and the parties are going to proceed with a divorce,
right.
Particularly with respect to alimony and the division of assets. So that's a very common type of a circumstance we would see with a postnuptial agreement.
Sure.
And then the last sort of section of cases that we do are parties that were never married, that have children.
Yeah.
And so those are, we call them parenting cases. Both states recognize rights in parents, both with respect to the custodial parenting plan type issues, as in addition to with respect to the financial issues related to children.
Okay.
So those are issues that we deal with quite extensively as well.
Gotcha. It's funny you mentioned modification. So I think a lot of people, and we see this in what I do as well, they think once they do their estate plan and they do their documents and that's it and they're done and we never have to look at them again and they never have to be reviewed or changed. And one of the things we tell clients is that, no, this is not a one and done process. This is something that goes on over time because things change, circumstances change. People get married, people have kids, people pass away, and those types of things can require a change in their plan. And so, we tell clients these things can come up down the road. It's not just here's your binder and that's it and we'll never talk again. And it sounds like you see some of that as well. Even if you get a divorce action that's completed, you might need to see someone because there's been a change in circumstances. So now that relates back to the original judgment that you got, and things have to change. Again, custody, all that sort of stuff is always in fluid motion, right? It's not written in stone and it's finished. So people finish their case with you, but that doesn't mean you're never going to see them again because this stuff comes up.
That's
right?
very true. We have a lot of repeat clients, particularly if at the time we represented them in their divorce or in their parenting case, the children were young.
Yeah.
Then you're going to have lots of issues that are going to happen as time goes on, just by nature of the passage of time.
Right.
A parenting plan for a 3-year-old is going to be different than a parenting plan for a 12-year-old.
Right.
And then the finances are going to obviously change quite extensively once the child ages. In Massachusetts, the issue of payment of college expenses is a big one that we have had whole cases just on that issue. In New Hampshire, it's very different. There's no legal obligation to contribute to college in New Hampshire unless the parties voluntarily choose to make it a binding enforceable legal obligation, which is extremely rare.
Yeah, yeah.
If you don't have to, typically the advice is don't commit to a binding legal obligation going forward.
And I get it, because when you've got kids that are 3 or 4, it's hard to think about, even wrapping your head around that when, them being college age. But so my kids are college age. I dropped my daughter off last week for her first year of college. My son's a senior in high school, so, he's a year behind. So next year they'll both be gone. And the costs are so astronomical that I could see that as an issue that people might want to deal with, or at least have an understanding of when it comes to their parenting plan of who's going to do what. Because, you go broke paying for this stuff.
And this is one of the issues that I see very frequently on modification actions in my Massachusetts practice, because the parties don't know, obviously, at the time of the divorce. In all cases, they're not going to know what their finances will be. They're not going to know whether their child is going to a state school versus a private school that's considerably more expensive. They're not going to know what type of financial aid or scholarships or grants the child might be eligible for. So there's lots of circumstances that can change with respect to the contributions towards college. And Massachusetts law does provide us with some guidelines with respect to contributions towards college, but it is so case specific because it will depend on the party's financial circumstances at the time that the expenses arise.
Yeah.
It'll depend on where the children are going to college. It'll depend on so many different factors. So these are cases that we very frequently do see come back to us. Typically, if I'm drafting a divorce agreement with a case with very, very young children, our language in our divorce agreement will be very broad and very general and generic, because we just don't know a lot of these future changes that may take place. And so those are the cases that will most often come back. Unfortunately, parties do often spend a lot of legal fees, sometimes enough to cover a year or more of college tuition, sometimes just fighting this. But obviously, that's something that the lawyer on both sides of the case is obligated to discuss with the client, because at some point it makes sense to try to come to some resolution so you don't spend all that money that can be more appropriately earmarked for the children's college expenses.
Yeah, I could see how you could have cases based on just that issue. If you've got kids that are in high school, maybe we're a little closer, right? So we're not projecting as far out as to what our financial circumstances are going to be, or are they even going to go to college? But when they're 3, 4, or 5 years old, who the heck knows what our financial situation is going to be in 14 years, 13 years. So it's definitely something I could see that becomes an issue later, or could become an issue later and then come back and turn into a case where you're just dealing with that. So I'm licensed in New Hampshire and Mass as well, and not going to lie, Massachusetts stuff when it comes to estate planning is a lot more tricky than New Hampshire. What do you find in your practice, or are they the same?
So there are significant differences between family law practice in Massachusetts and New Hampshire, both from a substantive law perspective as well as from procedural perspective. So in Massachusetts, unfortunately, the courts have never been able to master the art of scheduling hearings so that you go to court, you're scheduled for 9 o'clock, and your hearing happens at 9 o'clock.
Right.
In Massachusetts, if I have something scheduled at 9 o'clock, I don't book anything later in the day until maybe 3 o'clock.
Yeah.
In New Hampshire, they have perfected that process, and it's one of my favorite things about practicing in New Hampshire. If your hearing is scheduled for 9 o'clock, you are pretty much going to go at 9 o'clock.
Wow.
You might have a small overlap if another case goes long, but I don't think I've ever had more than maybe an hour delay in a New Hampshire scheduled case.
Okay.
Versus in Massachusetts, I can be in court for 7 or 8 hours.
Absolutely.
So it becomes more expensive to litigate in Massachusetts, which is something that we have to keep our clients appraised of. We do, as I indicated, have 6 attorneys in our firm, 2 of which are associates. They're excellent, but they are obviously younger lawyers, so their hourly rates are lower than the partners' rates.
Yeah.
So that's a cost-effective approach for some clients, depending on the size of the marital estate and the complexity of the issues involved. But some of the really big procedural differences between Mass and New Hampshire involve how you file things, how people are served. That's very different in the 2 states.
Okay.
For example, in Massachusetts, when you serve a divorce, it has to be served in hand on the person.
Right.
It cannot be served leaving at their home or leaving at their work or emailing to them or just mailing to them certified mail.
Right.
It has to be served in hand. That's a unique rule in Massachusetts. New Hampshire has a very different approach where they mail out an introductory letter to the other party to let them know that the matter has been filed by their spouse and they need to come to the court and retrieve their copy.
Okay.
And if they don't, then you have them served, but it doesn't have to be in hand. So there's very different
Quite
procedural requirements. But one of the biggest differences between Mass and New Hampshire is substantive law in family law. For example, I mentioned it previously, there is no legal obligation to contribute to college expenses in New Hampshire. New Hampshire did recently change its laws to allow the parties to negotiate an enforceable obligation, but that is extremely rare.
Yeah.
The other big difference between my Mass practice and my New Hampshire practice is New Hampshire practice, child support ends when the child is 18 or graduates from high school, whichever is later.
Okay. Yeah.
But in Massachusetts, it's
very
23 or graduation from college,
Yeah.
whichever is first. It is very, very different.
Sure.
They have different guidelines for how you calculate child support. There are differences in their approach to calculations of alimony. Alimony has gone through a lot of reform, both on a state level as well as on the federal level, as you may know.
Yep.
In 2019, January of 2019, alimony became non-taxable income to the recipient and non-deductible to the person who's paying it, which threw all states into somewhat of a quandary because we all have approaches that dealt with the assumption that alimony would be a tax-deductible vehicle. It is no longer, so that's very different both from the state and the federal level. That has evolved quite substantially, and both states do approach that very differently as well.
Yeah, one of the biggest differences we see in what I do with estate planning has to do with tax. Massachusetts has an estate tax. It's a very, very low threshold. New Hampshire does not. It's a totally different ballgame. So, I have to look at Massachusetts cases very, very differently from an estate plan that we're doing for someone that's a New Hampshire resident. So, and New Hampshire, at least on my side of things, I like the way I'm a Mass resident, but I like the way they do it better than we do it here. And for you to say that you're having these scheduled hearings and you're showing up at 9 and you're having your hearing right around 9, that's my mind is blown because I don't very often have to go to court in what I do, but when I do have to go to probate court here in Massachusetts, it's an all-day affair. I had a case last week, and so I said, okay, I need to book the whole day for this. We can't schedule anything else because I don't know what time I'm going to end up getting back. It ended up getting continued anyway. I didn't have to go. But I blocked that whole day for something that should have been done at 9 in the morning. So it's amazing to me that New Hampshire seems to have perfected that.
I wish Massachusetts could take a lesson from New Hampshire. I will say, though, that since the pandemic, We are now doing in Massachusetts some hearings via Zoom.
Yeah.
Certainly a lot more when we were in the throes of the pandemic than we are now. I am finding, disappointingly from my perspective, that judges seem a little more reluctant to do the Zoom hearings. There is something different about being in person as opposed to being on a computer.
Yeah.
There's just a different feel to the hearing, to the formality of the hearing. There's also a different, sometimes a different result, because oftentimes if you are in court, it is not uncommon, particularly in my Massachusetts practice, where you may negotiate while you're there.
Yeah.
And you may actually put something on paper
Right.
and have a court approve it while you're there and save the client the cost and time of another hearing.
Sure.
You can't obviously do that as easily in a Zoom hearing, but the Zoom hearings have proven to be extremely beneficial, both from a time and a cost perspective for my clients, if you have something that's simple like a continuance or an agreed upon document that you just need the court to approve.
Right.
Those types of things, judges seem a little more open to continuing to do via Zoom.
Okay.
And it's funny, when I'm in court in Massachusetts, I now have to sit for an hour while the judge does all his or her Zoom hearings. So I'm sitting there listening to all the Zoom hearings.
Yeah.
And then they do the in-person hearings.
Right.
So
Right.
it's a different world that we're living in now, but at least I think that the pandemic has given us these tools electronically that do give us better access to the courts. Sometimes access that would be extremely expensive for clients. I have a client who has been in California, lived in California until very recently, so for her to come back and forth for hearings would be cost prohibitive potentially.
Yeah.
So that has been really helpful for her, and also clients with disabilities and special needs that have childcare issues. Being able to do these hearings electronically has been very helpful for them. New Hampshire, unfortunately, never really offered much by way of electronic hearings other than by telephone, and there were lots of problems, including people impersonating other people and so on. So that didn't turn out to be a good exercise. So now all the hearings are in person in New Hampshire for sure.
Okay.
So
when I was sworn into the New Hampshire bar, it was done by Zoom.
Oh,
It was it's a couple of years ago now, but it was mid-pandemic.
yeah.
And so we did a Zoom meeting, and we took the oath and everything, and we were sworn in by Zoom. And it was funny because the judge that was administering the oath felt really bad that we weren't able to be there in person in the courtroom, but for me, it saved me the whole day.
Yeah.
So I was, this is the best. I hope they don't go back to forcing us to be there in person. It'd be great if it could be an option, because I was able to, wasn't my first bar that I was sworn into. I was already a member of Massachusetts and New York, so if it had been my very first one, maybe I would have wanted to go there in person and go through the whole formality. But for me, at the time, it was my third one. I was totally okay with doing it by Zoom and saving myself the travel time back and forth. And I was wondering if that was something that was going to stick around. But it sounds like in New Hampshire, at least for the hearings and that sort of thing, they're not doing it.
They're not. They even at one point sent me a trial notice for a 6-hour trial to take place by telephone in one of my New Hampshire cases. Like, this is
how could you do that?
It's impossible.
Oh, wow.
So we filed a motion, and the court granted it. But at that point, the restrictions were fortunately starting to lift. But the Zoom has proved to be very cost effective and very time effective. I have had Zoom hearings in Massachusetts where I have literally sat in the waiting room for 3 hours.
Yeah.
My record, I think, is probably close to 3.5. But the good news for the client is I'm able to multitask. And so the client doesn't necessarily have to pay for every minute of those 3 hours, because in family law we do bill on an hourly basis.
Right.
Particularly in Massachusetts, where I could go to court at 9 o'clock and be done at 4 o'clock, versus in New Hampshire, where it's a lot more predictable as to how long I'm going to be required to be out of the office.
At least you can work on a couple of things maybe at the same time, instead of just sitting there and staring at the countdown and watching how long you've been in the waiting room. That's crazy to me. I get asked a lot, how did I end up becoming an estate planning lawyer? When I first started out, I was general practice. I worked for a small firm. They did a lot of divorce work, but I never really got into it. And I was doing a lot of real estate work, and it ended up, I got into estate planning to help my grandparents when my grandfather got sick. He started having signs of dementia, and no one knew what to do, and I was kind of thrust into, okay, I need to figure this out to help them, and realize that I enjoyed it, and I stayed. So how did you get into doing the work that you do now? What led you there?
So it's actually kind of a funny story. So when I first graduated law school, I had been doing real estate law as a paralegal during law school and immediately after. But I knew I wanted to be a litigator.
Yeah.
That I knew. I just knew I wanted to be a litigator. I thought I wanted to do criminal work. I thought I wanted to be a criminal defense attorney. I had done a clinical program in the prosecutor's office during law school, and I had gotten a taste of what it's like to be in court. I really liked that, and I wanted to continue that. So I started out by doing some criminal defense work. And in the early years of practice, as I'm sure you know, we have a lot of time because we don't have any clients yet and not a lot of money. And so I was renting space from an old-time lawyer in Revere, Massachusetts, who did all different types of law. And he basically gave me a free office in exchange for giving him 40 hours free of my legal services per month.
Yeah.
And so I was furnishing my office, my new free office, and I went to Office Max, which is an old pre-Staples type store we used to have. You might remember Office Max.
Are they completely gone now?
I think they are. I think it's Office Depot now. Yeah. And the man who sold me my furniture for my very first office became my first divorce client.
Oh my God.
He became my first divorce client. We got to talking, and I hadn't really decided what I would do beyond the criminal area of practice. I was already doing some criminal defense work as a bar advocate, which is basically working cases where you're paid by the state, though you're not a state employee. Yeah. So it gave me a good opportunity to get started. It was sort of a way to have some revenue while I built my practice and figured out which direction I would head in. So he became my very first divorce client. And I quickly realized that divorce litigation was very different than criminal litigation. Yeah. I liked it. I enjoyed the different challenges. The cases are very different depending on the facts. It gave me an opportunity to be able to advocate as well as an opportunity to feel intellectually challenged because each case has very unique issues. There's a lot of strategy involved. And so that was sort of the beginning, and it sort of expanded from there. I did do criminal work for a number of years. I haven't done criminal work in many, many years. One of my partners in New Hampshire is a former state's attorney in New Hampshire, so she does some criminal work, but she also does family law. And it was actually an easy transition from criminal into family law. You are still dealing with individuals versus dealing with people one-on-one. People come to you, I'm sure for your practice as well, at a time in their life where they're either going through something really difficult, or they're discussing in your situation with what you practice, they're discussing the future end of their lives, and that's obviously difficult to discuss. So it does require the ability to be compassionate, but also to be to some degree objective. And I don't mean objective that you don't take your client's position, but how I can best serve my clients is to give them the information that will help them make the best strategic decisions for them and for their family. I'm sure you practice the same.
All the time.
And that means that at times I can't always tell a client what he or she wants to hear.
Yeah.
And that is something that I actually say to pretty much every prospective client during an initial consult. I am the type of attorney who's really going to help you understand the law. I'm going to make sure that you understand your options, and I'm going to make sure that you understand what I believe based on my, at this point, almost 30 years of experience, what a likely result is, where your case is very likely to end up. And so that's pretty similar in these areas of practice that I was handling at the time, both in a criminal case as well as in a family law case. I mistakenly thought family law would be easier, and I was very wrong. It is definitely not easier, and the cases do last sometimes a really long time. I have one case going on at this point. We're probably about 3.5 years, and I think by the time we ultimately get a decision from the judge, we did try the case for several days, it'll probably be closer to 4 years. That's rare. I'd say the average divorce is concluded within a year or less, and if it's amicable, it can be weeks or months. Every case is different. Clients always ask me, how long is it going to take for this case to be concluded, or how much is it going to cost me? And in family law cases where we bill hourly and we can't predict what is going to happen in terms of the other side's responsiveness, in terms of the other side's reasonableness,
Right.
in terms of the other lawyer's responsiveness and the other lawyer's reasonableness, which unfortunately can sometimes seriously impact your case.
Yeah.
We can't predict what's going to happen with the courts. Who could have predicted a global pandemic? That, of course, through, I'm sure you would do the same
Oh my God.
as with my clients,
Yeah.
through so many of my cases, threw them into, essentially chaos. We have been busier since the pandemic began than ever in the 30 years. And I think that's a combination of the pandemic forcing people to a breaking point. I think it's a combination of people that might have been holding off, and then the pandemic hit, and now they couldn't really do anything.
Yeah.
So then everybody's now racing to get it done. And I think the pandemic, of course, changed people's financial circumstances so dramatically.
Definitely. And at the end of the day, we're talking about people here, real people, not big companies, not insurance companies. We're talking about you being able to help real people that are going through something that's difficult. It's not something they're going to remember as the best time in their life, and you're able to help them through that. And that's similar with what I do. I deal with people that maybe their parent needs to go to a nursing home because they have dementia, or maybe someone's passed away, and so we need to do probate estate for them. Or even if we're just doing basic estate planning, we're talking about someone having to contemplate their own death. What happens if I'm not here? What happens to my spouse? What happens to my kids? What happens to my money in my house? And so being able to help people that are going through something that's difficult or confusing, it's one of my favorite things about what I do, is being able to assist people when they're not at their best. And so I imagine it's the same for you, because you're seeing people that are going through something that's difficult, and you're able to kind of be there and take some of that burden that they're feeling and give them advice about what to do.
It's so true. I mean, when the divorce is over and we have that final hearing, as we do in Massachusetts, New Hampshire, you can actually get divorced and never step foot in the courthouse, if you can believe it. But in Massachusetts, you still have to have that final hearing. And I often find myself, reacting differently when it's over. There are some clients where I definitely say congratulations, and they want to give you a big hug, and they're just so happy it's done.
Yeah.
There are other clients who are crying and upset. There are some clients who the parties leave together. The parties that just got divorced, I've had that happen a couple of times.
Okay.
So the reaction when it's over is very different depending on the circumstances of your case. But overall, there is that sense of relief, I feel, for my client, especially if we're able to settle their case and not have to gamble, essentially, on taking the matter before a judge, because you just never know what's going to happen.
Never predict it.
You never know. So it is something that does happen. Not common in my mass practice. I would say probably 95% of my Massachusetts cases will settle without having to go through an actual formal trial. New Hampshire, probably a little bit less. I'd say about 90%. It is less costly to litigate in New Hampshire. I think the cases do move along a little more quickly.
All right.
The court does decide more issues just on the pleadings themselves. Not every single solitary issue requires a hearing. And if you do settle your case, there is no hearing required in my New Hampshire practice.
Wow.
Unlike Massachusetts, which for the most part, all cases will ultimately require some final hearing where the court will confirm that the parties have reviewed the final agreement, understand it, have made full disclosure, and that the court will make a finding that the agreement is fair and that it's reasonable and that everybody has made full disclosure of all the relevant information. So, that is another difference between the two states.
Yeah, in Mass, you have to go in for that. You think even if you have an agreement, hey, why should we have to go in front of the judge? We have an agreement, but you have to. It's part of the process. It's not the same everywhere. Years and years ago when I first started, and I used to do a little bit of even uncontested divorce work, and we'd come up with an agreement, and clients would ask, why do we have to go in front of the judge? But it's part of the process, and every judge is different. I used to have the same judge give me different feedback on the same agreement two different times. They'd approve it one day, and I'd have the exact same agreement with a different case the next day, and they'd go out in the hall and change this paragraph. So it's impossible to predict. So when you're talking about litigating and having it is kind of a gamble because you don't know how long it's going to take, who's going to be responsive, who's not, how much of your time is going to be involved, so therefore what it's going to cost, and you never know what a judge is going to do. In the end, they might do something the same way 10 times, in the 11th it's different, right?
Yeah, it's always so unpredictable, but the added stressors are that they do sometimes make changes in the court itself. I was mentioning to you earlier that they just recently reassigned 5 different judges between counties, not even within the same county.
Okay. Wow.
So I have a couple of cases going on right now in Essex County, that's either in Lawrence or in Salem. These happen to be Lawrence cases where we've had this one judge through many, many hearings, and in one case through a detailed guardian ad litem investigation, and now suddenly we have a brand new judge. And so the case is essentially starting from scratch. We now have another, I think our court date is April, so however many months that is before we even have another court hearing of substance on the case. And so those are factors and circumstances that obviously nobody could have predicted.
Nothing you can do about it. You can't predict it. It's got to be difficult on the client to say, now we're almost starting from scratch, even though we've done all these steps and have to start over. That's going to be a tough conversation, but it's out of your control. We're at the mercy of the court in a lot of ways when it comes to this stuff.
Exactly. Exactly.
All right, let me pick your brain. So I always try to find out the kind of inside track on some things. So if we've got somebody that is preparing to file for divorce. There's no more, I think maybe I'm going to, they know, okay, it's time. Is there any tips, anything that you would advise for somebody? Should the first step be to come and see a lawyer? Should they be doing something else? Should they be doing something with their money? What's kind of, okay, I realize that it's time and I need to start this process of getting divorced. What's kind of a good way, is it call you and that's step one, or I don't know from not being in that same world you are. And clients do ask me, even when we're doing estate planning, and one spouse will leave the room and the other one will tell me, I don't think this is going to go on for very long. What should they be doing kind of early on that made this decision? Now what?
Well, I definitely would agree that step one is to contact an attorney. Many attorneys will offer an initial consultation complimentary.
Yeah.
We typically offer 30 minutes either by Zoom or telephone. The initial discussions with a paralegal or legal assistant just so that we can obtain basic information and run a conflict check, and then they're scheduled to speak with one of our attorneys for 30 minutes or so. I often exceed my 30 minutes with the clients depending on the complexity of their case or if there are any unique issues that need to be addressed. That I would suggest is the first step because the planning for preparing for a divorce is going to depend on the facts and circumstances of your case. So, for example, I have a new client who just retained me to represent her, who just received an inheritance in the hundreds of thousands of dollars, and she received it in, I believe, May. And I wish she had consulted with me because she immediately put those funds into joint names with her husband.
Okay.
And that has an impact on the divorce. So that would have been a really a different path that I would have encouraged her to take with respect to those monies. So I never encourage clients to start immediately moving money around.
Yeah.
That, I think, is a red flag not only to the other party but also potentially to a judge.
Okay.
If I do have a client who has limited funds at his or her disposal, I may suggest to them that they take half of a particular account if there is some fear that the other spouse may cut them off and they have no ability to retain counsel, pay for food, pay for whatever their children need, whatever it may be. So I may advise them to do that. But the first step should be to have a consult with me or somebody who specializes in family law. Most lawyers will offer a 30-minute consult, usually complimentary. Not all. I think the closer you get to Boston, the less likely that's true. Sure. Typically, clients, will maybe want a second or a third consult. I will charge them for that. Sometimes clients will just retain me so that they can schedule an appointment to discuss whatever happens to be going on at the moment. They're not ready to pull the trigger, so to speak, and actually file for divorce, but they have changes that are happening and the relationship is evolving and they're not ready to get divorced yet or to file for divorce yet. But they know that it's sort of heading in that direction, and they want to be able to call me and not worry.
Yeah.
So they, retain me to just as needed basis. And I would say that probably 9 out of 10 times they will ultimately become a client. That generally, if you're getting to the point where you're consulting with a divorce attorney, more often than not, you do usually head in that direction, in my experience.
Yeah.
To tie things in with your area of practice, when I do consult with a client in the early days of the case, I need to understand the economics of the party's circumstances, obviously the children, any special needs.
Right.
I need to understand if there's estate planning already in place,
Right.
because that'll have to change
Sure.
if the parties are going to get divorced.
Yeah.
And I need to understand whether they are named beneficiaries of any other individuals' estate planning, for example, a parent or a grandparent. That can be a very big issue in a case. The court is required to consider a person's ability to acquire assets or income in the future when dividing up assets in both states in which I practice. And so if you've got a parent who's 95 years old in hospice and you're about to inherit millions of dollars, that may change
That's a factor,
what the court might do with respect to the actual marital assets being divided.
Okay.
So these are all pieces of information that I need to get from the client. We keep detailed notes when we consult with a client, and then when they're ready to actually proceed, we have a system where we can retrieve the information, we can update, find out what's changed since the last time we consulted, and then proceed however they have chosen to proceed at that point. So, there are different ways that a client sometimes utilizes my services. I've got cases in which a client likes to go to mediation without the attorney present. And I may be in the background and help the client in terms of preparing for that mediation.
Okay. Yeah.
Again, understanding the economics, understanding whether they're about to inherit any money, whether they have an estate plan in place, whether they have a child in private school versus in public school, whether there's a job change. I mean, all of these issues have to be discussed and have to be vetted so that they can, properly advocate for themselves in the mediation.
Right.
There are cases where I go to the mediation with the client.
Yeah.
In New Hampshire, mediation is mandatory in all cases that involve minor children. If you're unable to resolve your case, you have to at least attempt mediation. In Massachusetts, it's not mandatory, but I would say that it's becoming more and more popular.
Yeah, I think the judges like it.
Judges love it. I volunteer my time periodically to help the courts if they need a case where the parties either can't afford a mediator or their mediation was unsuccessful. Sometimes I'll mediate a case through different programs that the courts offer to try to reach a result. There's all different forms of alternative dispute resolution available, some of which are paid alternative dispute resolution, some of which are very low cost to the party. So it depends on what state I'm in and what county I'm in, particularly if it's in Massachusetts. There are some county programs as well.
That can save time, it can save money,
Absolutely.
It can get things done, a lot faster.
Absolutely.
So it's a good thing if it works. I like that New Hampshire requires it. I think in Massachusetts maybe it's not required, but the judges like it and they want to know that you gave it a shot, or they tell them that it's not going to happen. There's no way that we're going to reach an agreement. Even sometimes in those cases, you give it a go and you might.
They have nothing to lose. I mean,
Yeah.
mediation is basically a confidential process. The parties have nothing to lose other than the cost of the mediation,
Right.
which is something. That's not obviously inconsiderable depending on the cost of your mediator and how much time you spend on the mediation, but it's actually, to me, it's also free information. So if I have a mediation and we're unsuccessful, I have now gathered some information about their position on settlement, their arguments. So I don't consider mediation to be a waste of time and money. And I will say that since I've been practicing in New Hampshire, I've been practicing in New Hampshire since 2010. And I've been practicing in Massachusetts a lot longer. So I have a growing respect for mediation and the benefits that it can offer the clients because of my New Hampshire practice. It was never mandated in my Massachusetts practice. And so people don't always opt to try it. And in New Hampshire, you have no choice if you have minor children, and so many more cases actually go through this mediation process, and they offer this very inexpensive court-appointed mediation in New Hampshire. So, that's given me a growing respect for mediation, and I think I've brought that into my Massachusetts practice as well, and more cases I think I steer that are appropriate for alternative dispute resolution to mediation or some other form of resolution that doesn't necessarily involve essentially rolling the dice with a judge.
Gotcha. So that's great information. All right, talk to me about, and I think I already kept you longer than I said I was going to. Last thing I want to ask you. So, okay, I'm at the point where, all right, I think this needs to happen. I need to talk to an attorney. Maybe I'm ready to go forward with divorce, or I'm thinking about it, or I have questions about it. If I want to get in touch with you and I want to talk to you and potentially hire you to be my lawyer for my divorce, how do I start? Is it the website? Do I call you? Is it all of the above? How does someone take that first step with you?
So it's very simple. You can either go to our website, which is theblacklawgroup.com, and it is theblacklawgroup.com. And all of our attorneys' profiles are on our website with their email addresses and contact information. Of course, our phone numbers are also on the website. Yep. We do receive a lot of potential new clients through the internet. We are also a member of several referral services as well. But I think whatever's easiest for the client. Some clients prefer to just pick up the phone. Mm-hmm. Other clients prefer to send an email. Ultimately, you will need to have an initial consultation with one of our paralegals or legal assistants so that we can run a conflict check, make sure it's the type of case that we would handle, go through the lawyer's hourly rates and retainer requirements, depending on which attorney that you may want to work with in our firm. And then we schedule that consult with the attorney themselves. So either way, initial contact can be by email or it can be by telephone, whichever is more convenient for the client. Obviously, during business hours for telephone calls is preferable. We have many potential clients reach out to us after hours or on the weekend, and then we just respond and get back to them during business hours.
Sure. Right. That's great. This was excellent. I appreciate it so much.
Thank you for having
information.
me.
Thank you for taking the time with me. I took more time from you than I said I was going to, but I appreciate it.
Thank you.
This was great. I know it's going to be super useful to my clients. It's just great info to have. So thanks so much.
Thank you very much, and I really appreciate that you had given me the opportunity to speak with your potential clients and to speak with your existing clients.
My pleasure. Thanks so much.